Hi, my name is Jacob Krynick, and today I will be talking about intellectual property. More specifically, I'll be going into detail about some of the different kinds of intellectual property, how this property is protected under the law, and the point of having laws protecting intellectual property, and some instances where these laws can be harmful. Intellectual property is not physical property, but rather is an idea or creation that belongs to an individual. Some examples of intellectual property are inventions, music, physical art, literature, logos, symbols, business names, slogans, and even words can be considered intellectual property. Different classifications of intellectual property encompass these forms. The reason for classifying types of intellectual property is so that it can be protected differently under the law. Different forms of intellectual property include patents, copyrights, trademarks, trade dress, and trade secrets. Each one of these categories represent different types of intellectual property, and each category has a specific set of laws that protect the type of specific property that each category embodies. I will go into more detail about each of these classifications of intellectual property later in the video. Patents are used to protect inventors from other people using, selling, or marketing their invention. The patent holder is the only one with the rights to their invention. When someone has created a specific product, they can file for a patent by filling out an application with the U.S. Patent and Trademark Office. According to Rich Beam, a patent law attorney, there are three different types of patents: utility, which is the most common, design, and plant. A utility patent relates to technology, and there has to do with how something works. Drawings show specifically how a certain product works. A design patent is used to outline specific ornamental designs. If an invention has a specific shape and or color, this will be outlined in a design patent. The last type of patent is a plant patent. These type of patents are very uncommon but easy to attain. They are for people who are trying to make a certain type of hybrid plant. Copyrights protects original pieces of work. This can include, but is not limited to, art, music, screenplays, TV shows, computer software, and literature. To make sure that these are protected from being stolen, copyright gives exclusive rights to the creator for their full lifetime plus 70 years. After this time expires, anyone can use the work and is considered in the public domain. The public domain means that after copyrights and patents expire, anyone is free to use the work, invention, or product. According to Up Counsel, trademarks protect company names, logos, slogans, or anything that distinguishes the source of goods from one business to another. An example of this could be "Have it your way," Burger King's slogan, or the iconic yellow M that is the logo for McDonald's. When people see the M or hear that slogan, people instantly know what company is being referred to, and this is why trademarks are put in place. Unlike some other forms of intellectual property, trademarks have no set amount of time they can last for. They can even potentially last forever if the company that owns the trademark continually fights for the rights to their name or slogan. Trade dress, similar to trademark, but instead of protecting a company's name or logo, it protects how a company's product looks or how it is packaged. The purpose of trade dress is to ensure that a person cannot make a similar looking product, making consumers mistake it for the actual product. Trade dress even extends to how a specific building can look. IHOP buildings have a blue slanted roof. No other business can replicate this exact structure of building. Just like trademarks, there is no specific time frame that a trade dress can last for. An example of a trade dress is that Apple claimed that they were the only ones that had the rights to make rectangular phones, and as a result, filed a lawsuit against Samsung for copying this. Furthermore, the Samsung Galaxy S3 was made by a team of Samsung's lawyers to ensure that it did not infringe on any of Apple's claims to trade dress. Trade secrets protect the way a certain company makes a product. No other company has access to a company's way of practice, secret formula, or way of making a certain product. The most famous example of this is the secret formula for Coca-Cola. Other companies like Pepsi make similar products, but they are far from the same. In the 1600s, John Locke theorized that if someone can claim ownership to a physical or abstract work, It would encourage people to create things that have the potential to benefit society as a whole. Ownership gives someone credit and the potential to make economic gains for an idea or work. The promotion or The promotion of creating something also fosters the spread of ideas. When more people make things, it leads to people being inspired and can lead to more innovation. While protecting people's property is important to promote people to create new things, when copyright laws are too strong, it can prevent people from creating innovative derivative works with the fear that they will get sued for copyright infringement. According to copyright and creativity, all works are based off of other works and other people's ideas. They call this standing on the shoulders of giants, and this is how new innovation comes about. Achieving a balance between strict and weaker laws is very hard to do, and it is part of the reason that leads copyright laws to be very complex. When patent and copyright law is too strong or too broad, it can lead to more than just people being afraid to create new works. According to John Oliver, when copyright law is broad, it can lead to companies suing other companies over applications of things like software. These companies do not create anything and often receive money for suit settlements. Such companies are called patent trolls. With many factors to consider when making copyright law, it is impossible to be perfect to protect against all things. However, even with all the complexities, copyright law does a pretty good job of creating a balance between incentivizing people to create new works and allowing people to create derivative works without the fear of being sued. Thank you for watching.